Hello friends, Namaskaram. How are you? Myself is Dr. Jineesh Soni. I am an advocate and a defense counsel. Har Har Mahadev, Jai Shiv Shambhu, Jai Mata Di. With the blessings of Almighty, in today's class we will study about the duty of IU, more specifically concerning the cases of Prevention of Corruption Act. As we know that investigation is not the mere formality. It involves the life and liberty of the accused. A wrong investigation might result in a serious perjury to the concerned accused. So basically, we have to observe the entire file in the light of principle whether the concerned IU has investigated the case as per norms or not. If it is found that or it is evident that the IU has not discharged the duty in the proper way, then we could have the benefit. So basically, we have to understand the instance so that we could work out and could put up the strong defense on record. So basically, we are going to observe the breakdown. Number one, the prosecution has to establish the demand. If there is mere recovery, mere acceptance, it is not sufficient regarding the prosecution and conviction. Demand must be on the record. Demand must be supported by the statement of complainant, shadow witness, electronic evidence, and apart from that, the story of prosecution should not be inconsistent and there must not be any lack of corroboration. If it occurs in that scenario, prosecution would fail. So IO has to verify whether demand is in existence or not. If demand is not in existence and despite of that the IO files a charge sheet, then we could file the objection in due course. And recently one of the trial court of Delhi had passed adverse remarks against the IO for doing the investigation against law. And the concerned court relied on section 119 subclause Z of BSA. So working on that principle, we could work out and we could submit our objections accordingly. Number two, it is the duty of IO to verify the complaint, to find out the allegations are genuine or not. Regarding this, the concerned IO is bound to follow the process or protocol of section 173 subclause 3 of BNSS. Point number three, the IO has to lay down the trap proceeding. And we have to keep in our mind that the trial proceedings are not mere formalities. The IO has to work out on the role of complainant, role of accused, role of punch witness, and apart from that, IO has to work out on the source of chemical, from where the chemicals are issued and after proceeding where they had been deposited. Regarding this, Malkhana entries are quite important. And apart from that, the IO has to ensure the demand and acceptance must be on the voluntarily basis. If it is grafted or evidences are obtained by the way of inducement, threat or promise, in that scenario, the IO has to do the investigation and has to submit his report accordingly as per the mandate. If there is any violation, then we could make the objection as per section 22, 23 of BSA. The IO has to prove that the recovery and acceptance is accompanied with demand. If demand is not proved, there is mere recovery, mere acceptance, the same could not be a basis for the prosecution. And apart from that, the IO has to collect the evidences in the corroborative way. Evidences might be a documentary evidence, it might be ocular, it might be electronic evidence. So evidence must be proper, it must be admissible, and apart from that, the process must be the due process. In addition to this, if the work of collection of evidence is delegated in that scenario, it must not be in violation of section 17 of PC8. And apart from that, if the case is of demand only, in that scenario, the IO is bound to follow section 17A of PC8. If there is non-compliance, there is breach of duty, then the concerned accused could have the benefit. And apart from that, if there is any requirement of sanction, as per mandate of section 19 of PC8, in that scenario, the IO has to ensure that the authority is competent to accord sanction and there is application of mind. If all the scenarios are not verified, in that scenario, the accused could have the benefit. Apart from that, the IO has to maintain the chain of custody. If the chain of custody is diluted, it is compromised, in that scenario, the accused could have the benefit. In addition to this, the IO has to ensure the fair investigation. If there is any memorandum submitted by the concerned accused, the IO has to investigate and has to submit the report accordingly. In the simple words, I have specified you the duties of concerned IO. So whenever you are going to study your case, please keep in your mind the set guidelines so that you could have the effective case on the board. See you in the next lecture.